Comparative legal systems demonstrate that although the rules of evidence in administrative law vary from one jurisdiction to another, they share a common objective: ensuring fairness, accountability, transparency, and lawful decisions. Countries that follow the common law tradition, such as the United Kingdom, the United States, Canada, Pakistan, India, and Australia, generally recognize that administrative tribunals should not be constrained by the rigid technical rules governing evidence in ordinary courts. Instead, these jurisdictions allow administrative agencies to admit any evidence that is relevant, reliable, and capable of assisting the decision-making process. This approach reflects the practical reality that administrative bodies frequently deal with specialized matters involving taxation, immigration, environmental regulation, labor disputes, public procurement, education, healthcare, telecommunications, banking, and professional discipline. Strict adherence to courtroom evidentiary rules would often delay proceedings, increase costs, and undermine the efficiency expected from administrative institutions. Nevertheless, the flexibility granted to administrative authorities is accompanied by corresponding responsibilities. Decision-makers must remain impartial, evaluate evidence objectively, provide affected individuals with a fair opportunity to present their cases, and ensure that every conclusion is supported by sufficient factual material. Thus, comparative legal experience confirms that procedural flexibility should strengthen rather than weaken the principles of justice. Administrative tribunals also differ significantly from ordinary courts because they are designed to resolve disputes in a more accessible and less adversarial manner. Unlike judges in traditional courts, administrative decision-makers often possess specialized knowledge relating to the subject matter of the dispute. For example, labor tribunals understand employment relationships. Environmental authorities possess scientific expertise. Tax tribunals specialize in financial regulations, and immigration boards develop extensive knowledge of refugee and nationality law. This expertise enables administrative authorities to evaluate technical evidence more effectively than general courts. However, specialized knowledge should complement, not replace, objective evidence. Decision-makers cannot rely solely upon their personal expertise or assumptions when determining disputed facts. Their conclusions must always be supported by evidence that appears on the administrative record and that has been made available to the parties wherever fairness requires. Courts have repeatedly emphasized that expertise cannot justify arbitrary decision-making or compensate for the absence of reliable evidence. Consequently, even highly experienced administrative authorities remain legally bound to explain how the evidence supports their findings. The principle of equality of arms is another important evidentiary safeguard within administrative law. Equality of arms requires that every party participating in administrative proceedings should have a reasonable opportunity to present evidence, challenge opposing evidence, and advance legal arguments under conditions that do not place either side at a substantial disadvantage. This principle promotes procedural fairness by ensuring that government agencies do not misuse their superior resources or institutional authority against individual citizens. In many administrative disputes, the government possesses extensive documentation, investigative powers, expert resources, and legal representation, whereas ordinary individuals may have limited financial means and legal knowledge. To reduce this imbalance, administrative procedures often permit flexible presentation of evidence, simplified hearings, legal assistance where available, and opportunities to submit written explanations or supporting documents. Administrative decision-makers should actively ensure that self-represented individuals understand the procedure and receive a genuine opportunity to present relevant evidence. Equality of arms, therefore, strengthens public confidence by demonstrating that administrative justice remains accessible regardless of a person's social or economic position. Another crucial aspect of evidentiary rules concerns the exclusion of irrelevant or improperly obtained evidence. Although administrative tribunals generally adopt a liberal approach toward admissibility, not every piece of information deserves evidentiary weight. Evidence that is unrelated to the issues under consideration, obtained through unlawful methods, influenced by bias, or lacking sufficient credibility may properly be excluded or assigned little importance. Administrative authorities must distinguish between information that genuinely assists in discovering the truth and information that merely creates prejudice or confusion. For instance, personal opinions unsupported by factual material, anonymous accusations lacking corroboration, forged documents, manipulated electronic records, or discriminatory assumptions should never become the basis of administrative findings. Similarly, where evidence has been obtained in violation of statutory protections relating to privacy, confidentiality, or fundamental rights, administrative authorities must carefully consider whether reliance upon such material would undermine the fairness and legality of the proceedings. The objective is not merely to gather the greatest quantity of evidence, but to ensure that the evidence relied upon possesses sufficient quality, reliability, and legitimacy. Transparency represents another indispensable component of evidentiary fairness in administrative law. Public confidence in government institutions depends largely upon the openness and accountability of administrative authorities should maintain accurate records of proceedings, preserve documentary evidence, explain procedural steps, and provide written decisions that clearly identify the evidence supporting their conclusions. Proper record-keeping serves several important purposes. It protects the rights of affected individuals, facilitates appeals and judicial review, promotes institutional consistency, and encourages responsible decision-making by public officials. In the absence of adequate records, reviewing courts may find it difficult to determine whether relevant evidence was considered or whether the decision resulted from arbitrary reasoning. Consequently, modern administrative systems increasingly require agencies to maintain organized files containing applications, correspondence investigation reports, witness statements, expert opinions, hearing transcripts, documentary exhibits, and final decisions. These records form the evidentiary foundation upon which lawful administrative action is effected. Administrative evidence also plays a central role in combating corruption, abuse of authority, and maladministration. Public officials exercise extensive discretionary powers affecting economic activities, public employment, licensing, procurement, taxation, social welfare, and regulatory enforcement. Without proper evidentiary standards, these powers could easily be misused for personal benefit, political influence, favoritism, or discrimination. Reliable evidence, therefore, functions as an important safeguard against arbitrary governmental conduct. Administrative authorities should document investigations carefully, verify allegations objectively, maintain transparent decision-making processes, and avoid conflicts of interest throughout the proceedings. Independent review mechanisms, Apayate, tribunals, ombudsman, institutions, and judicial review further reinforce evidentiary accountability by ensuring that public officials cannot exercise authority without lawful justification. In this manner, evidentiary rules contribute not only to individual fairness, but also to broader principles of constitutional governance, public integrity. As administrative law continues to develop in response to globalization, technological innovation, and expanding governmental responsibilities, evidentiary standards must also evolve. Modern administrative agencies increasingly confront complex issues involving artificial intelligence, cybersecurity, environmental sustainability, international trade, digital governance, data protection, financial regulation, and cross-border cooperation. These developments require administrative authorities to evaluate new forms of technical and digital evidence, while continuing to respect traditional principles of procedural fairness. Regardless of technological advancement, the fundamental objectives of evidentiary rules remain unchanged. Administrative decisions must always be based upon relevant, credible, and sufficient evidence. Affected individuals must receive a fair opportunity to know and answer the case against them. Decision-makers must remain impartial and transparent, and reviewing courts must continue to ensure that administrative discretion is exercised lawfully. These enduring principles preserve the balance between efficient public administration and the protection of individual rights. Ultimately, the rules of evidence in administrative law serve not merely as procedural requirements, but as essential guarantees of justice, accountability, and the rule of law, ensuring that governmental power is exercised responsibly, rationally, and in accordance with the highest standards of fairness expected within a democratic legal system. The future of the rules of evidence in administrative law is closely connected with the continuing evolution of public administration, constitutional governance, and the protection of fundamental human rights. As governments expand their regulatory responsibilities to address increasingly complex social, economic, environmental, and technological challenges, administrative authorities are entrusted with broader powers that directly affect the daily lives of citizens. Decisions concerning employment, taxation, immigration, environmental protection, healthcare, education, social security, professional licensing, telecommunications, financial regulation, consumer protection, and public procurement require administrative agencies to evaluate enormous quantities of factual information before reaching lawful conclusions. In this context, the rules of evidence have become far more than procedural requirements. They have emerged as essential safeguards that preserve fairness, accountability, transparency, and public confidence in administrative governance. Every administrative decision must demonstrate that the authority carefully examined all relevant evidence, ignored irrelevant considerations, respected procedural fairness, and acted within the limits established by law. Without these evidentiary safeguards, administrative discretion could easily become arbitrary, inconsistent, or influenced by personal prejudice, political pressure, or institutional bias, thereby undermining the very purpose of administrative justice. An equally significant development in modern administrative law is the increasing recognition of human rights principles within evidentiary procedures. Democratic constitutions and international human rights instruments emphasize that every individual possesses the right to fair treatment whenever governmental action affects legal rights or legitimate interests. Consequently, administrative authorities must ensure that evidence is collected, evaluated, and relied upon in a manner consistent with dignity, equality, and procedural fairness. Individuals should receive adequate notice of proceedings, meaningful access to relevant evidence, sufficient opportunity to present their own evidence, and an impartial hearing before an unbiased decision. These guarantees strengthen not only individual rights, but also the legitimacy of governmental institutions. Citizens are far more likely to accept unfavorable decisions when they believe the process was transparent, respectful, and evident. Procedural fairness, therefore, serves both legal and democratic objectives by promoting voluntary compliance, reducing unnecessary litigation, and fostering trust between citizens and public authorities. The rapid development of technology presents both opportunities and challenges for evidentiary rules in administrative law. Digital governance has transformed the methods through which governments collect, store, analyze, and use information. Administrative agencies increasingly depend upon electronic records, biometric identification systems, artificial intelligence, automated online databases, digital communications, satellite imagery, electronic surveillance, and advanced data analytics. These technological innovations improve efficiency, accuracy, and accessibility, enabling governments to deliver public services more effectively. However, they also raise important legal concerns regarding privacy, cybersecurity, algorithmic bias, transparency, and the authenticity of digital evidence. Administrative authorities must therefore establish robust safeguards, ensuring that electronic evidence remains accurate, secure, and verifiable. Individuals affected by automated decisions should have meaningful opportunities to understand the evidence relied upon, challenge inaccuracies, and request human review, where appropriate. As administrative systems become increasingly digital, evidentiary rules must evolve to preserve fairness while embracing technological innovation. The challenge facing modern administrative law is not whether technology should be used, but how it should be used, responsibly and consistently with constitutional principles. International developments have also influenced the evolution of evidentiary standards in administrative law. Globalization has increased cooperation among governments in areas such as trade regulation, environmental protection, migration, public health, taxation, financial supervision, and anti-corruption enforcement. International organizations and comparative legal systems increasingly emphasize common principles of administrative justice, including transparency, accountability, participation, reasoned decision-making, proportionality, and procedural fairness. Although each country maintains its own legal traditions and institutional structures, there is growing recognition that administrative authorities should follow universally accepted standards regarding the treatment of evidence. Reliable evidence, impartial decision, and effective judicial oversight are now widely regarded as essential characteristics of good governance. Comparative experience demonstrates that societies prosper when public institutions operate according to objective legal standards rather than arbitrary discretion. Accordingly, Evidentiary principles continue to serve as bridges between national legal systems and internationally recognized standards of justice and administrative accountability. Another critical consideration involves public confidence in administrative institutions. The legitimacy of government depends not only upon the legality of administrative decisions, but also upon public perception that those decisions are fair, objective, and supported by evidence. Citizens expect public authorities to exercise their powers honestly, consistently, and without discrimination. When administrative agencies provide clear reasons for their decisions, identify the evidence supporting their conclusions, and demonstrate respect for procedural fairness, public trust is. Conversely, decisions that appear arbitrary, secretive, or unsupported by evidence undermine confidence in governmental institutions and encourage unnecessary litigation. Therefore, evidentiary transparency performs an essential democratic function by reassuring citizens that administrative power is exercised according to law rather than personal preference. Administrative authorities must remember that every decision represents not merely the resolution of an individual dispute, but also an expression of the government's commitment to justice, fairness, and the rule of law. Furthermore, legal education and professional training remain indispensable for improving evidentiary practices within administrative institutions. Public officials, investigators, hearing officers, regulatory inspectors, tribunal members, and legal advisors should receive continuous education concerning evidentiary principles, procedural fairness, ethical decision-making, digital evidence, and developments in administrative jurisprudence. Well-trained decision-makers are better equipped to distinguish reliable evidence from speculation, evaluate expert testimony objectively, recognize procedural irregularities, and prepare reasoned decisions capable of withstanding judicial scrutiny. Investment in professional competence ultimately enhances the quality of public administration, reduces legal disputes, and promotes consistent application of evidentiary standards across different administrative agencies. Strong institutions depend not only upon comprehensive legislation, but also upon knowledgeable and principled officials committed to the fair administration of justice. In conclusion, the rules of evidence in administrative law constitute one of the most important foundations of modern democratic governance. Although administrative proceedings differ significantly from ordinary judicial trials in terms of flexibility and procedure, they remain firmly governed by the enduring principles of relevance, reliability, fairness, transparency, accountability, and natural justice. Administrative authorities must ensure that every decision is supported by credible evidence. Every affected individual receives a meaningful opportunity to be heard, and every exercise of public power remains subject to judicial oversight. These principles protect individuals from arbitrary administrative action while enabling governments to perform their regulatory responsibilities effectively and efficiently. As society continues to evolve through technological advancement, globalization, and expanding governmental responsibilities, the importance of evidentiary safeguards will continue to increase. Ultimately, justice within administrative law is not measured by the number of decisions made or the speed with which they are delivered. It is measured by the fairness, integrity, and evidentiary strength upon which those decisions are built. When evidence is reliable, justice becomes credible. When justice is credible, the rule of law becomes unshakable. And when the rule of law stands firm, democracy itself is strengthened for present and future generations. This enduring relationship between evidence, fairness, and justice represents the true essence of administrative law and remains the cornerstone of every lawful and accountable system of public administration.